Today, in this video we will discuss the writ jurisdiction of the High Court, which is given in the Constitution of Pakistan 1973 under Article 199 Clause 1. What is writ? A writ is a formal written order issued by a court or other governmental body. In legal terminology, a writ is a type of order that is issued by a court or other governmental body to direct someone to do something or to stop doing something. What is writ petition? A writ petition is a legal document that is filed with a court in order to request a writ. The writ petition sets out the reasons why the petitioner, the person filing the writ petition, believes that a writ should be issued, and it is typically used as a way to seek relief from a court when no other legal remedies are available. Types of writs: Mandamus, Prohibition, Quo-Warranto, Certiorari, Habeas corpus. Mandamus. It's derived from the Latin word and its meaning is "we command." A mandamus is a judicial writ that is issued by a court to a lower court, government agency, or public authority to order them to perform a specific act that is required by law. Example: imagine that a city council is required by law to hold public meetings at least once a month. However, the council has not held a meeting in several months. A group of concerned citizens who want to address an issue at a council meeting may file a petition for a writ of mandamus with a court, arguing that the council is failing to fulfill its legal obligation to hold public meetings. If the court agrees, it will issue a writ of mandamus directing the council to hold a meeting. The council would then be required to hold the meeting as ordered by the court. Prohibition. Its meaning is to stop. A writ of prohibition is a court order that directs a lower court or government agency to stop proceeding with a particular case or matter because it lacks jurisdiction or authority to do so. Example: a person is charged with a crime in a lower court, but the crime was allegedly committed in another state. The person's lawyer argues that the lower court lacks jurisdiction over the case because the alleged crime was committed in another state and therefore should be tried in that state. The lawyer may file a petition for a writ of prohibition with an appellate court, asking the court to stop the lower court from proceeding with the case. If the appellate court agrees, it will issue a writ of prohibition directing the lower court to stop proceeding with the case. The lower court would then be prohibited from taking any further action in the case until the issue of jurisdiction is resolved. Quo-Warranto. It's derived from the Latin word and its meaning is, by what authority. Quo-Warranto is a legal writ or action that is used to challenge the right of an individual or entity to hold a particular public office or to exercise a particular franchise. Example: imagine that a person is elected to serve as the mayor of a city. However, it is later discovered that the person was not eligible to run for office because they did not meet the legal requirements for the position. For example, they did not meet the age or residency requirements. A group of citizens may file a petition for a writ of quo-warranto with a court, arguing that the person was not legally qualified to hold the office of mayor and therefore should be removed from the position. If the court agrees, it will issue a writ of quo-warranto directing the person to show cause why they should not be removed from office. Certiorari. It's derived from the Latin word and its meaning is to be certified. Certiorari is a legal term that refers to a writ or order issued by a higher court to a lower court, tribunal, or public authority, directing it to send the record of a case for review. It is a common law writ that is used in many legal systems to allow a higher court to review the decision of a lower court or other judicial body. Example: imagine that a person is convicted of a crime in a lower court and sentenced to prison. The person believes that the conviction was based on insufficient evidence or that the trial was otherwise unfair, and they want to appeal the decision. They may file a petition for a writ of certiorari with an appellate court, asking the court to review the case. If the appellate court agrees to hear the case, it will issue a writ of certiorari directing the lower court to send the case to the appellate court for review. The appellate court will then consider the case and decide whether to affirm the lower court's decision, reverse it, or remand it back to the lower court for further proceedings. Habeas corpus. It's derived from the Latin word and its meaning is to produce a body. Habeas corpus is a legal term that refers to a writ, or legal action, through which a person can challenge the legality of their detention or imprisonment. The writ of habeas corpus is a fundamental protection against unlawful detention, and it requires the government to justify the detention of an individual before a court. Example: imagine that a person is arrested and detained by the police without being charged with a crime. The person's family and friends believe that the detention is unlawful and seek to have the person released from custody. They may file a petition for a writ of habeas corpus with a court, arguing that the detention is illegal and that the person should be released. If the court agrees, it will issue a writ of habeas corpus directing the authorities to bring the detained person before the court. The court will then hold a hearing to determine whether the detention is legal and, if it is not, will order the person's release. Thanks for watching. Don't forget to like and subscribe.